most important things to an entrepreneur is their intellectual property. Many entrepreneurs don't just come up with a new system or process of doing something that already exists. They come up with something that's entirely new altogether. Maybe they come out with a new product or service. Maybe they come up with an idea that completely changes the way the market works going forward. Do you need a patent for that? Maybe you need a copyright or a trademark. Well, our guest today is going to break down which of those things you actually need for your business and what to do before registering for that patent, trademark, or copyright. Get ready to take some notes because today's guest has information you won't want to miss.
Welcome to this edition of Peak Performers Podcast with your host, Thor Conklin. Thor will be sharing the necessary tools, strategies, and psychology you'll need to become a peak performer in any area of your life or business.
Thor Conklin here. We give you the tricks, the tips, the tools, the strategy, the technology, and the psychology peak performers use in order to get more done and execute at the highest level. If you know what to do but struggle with getting it all done, or simply want to raise your game to the next level, this podcast is for you. Sit back and enjoy.
Today's guest is Vincent LoTempio, a registered patent attorney at the firm Kloss, Stanger & LoTempio. Vincent helps clients untangle the web of intellectual property law. If you're unsure whether your business needs a patent, copyright, or trademark, pay close attention. Vincent is going to give you all the information you need about IP law.
Vincent, thank you so much for joining us today. You know, this episode is going to speak about some things that are so important to entrepreneurs. And I want, if you're out there, you're listening, I want you to grab a notepad. I want you to grab a pen, because if you miss any of this stuff, it can come back and bite you in the butt. So Vincent, thank you very much for being on. And I'd like to say, you know, in the area of IP law, this stuff is really expensive to get attorneys working on any of your IP stuff. So thank you for coming on. Your time is extremely valuable, and I really appreciate that you carved out the time for us.
Well, thank you. I appreciate having the opportunity to talk to new inventors and make the connection. You know, that's part of my job, is just coming to work every day and just seeing the new ideas, and that's what makes it exciting. And the best part of my job is actually working with the people themselves, and it's not so much writing that term paper every day of your life. That's what writing patents and trademarks is kind of like.
Well, you know, it's funny. I mentor a lot of young college students, and sometimes they want to go on into a law degree. And I always tell them, if you're going to go into law, go into two things: M&A or IP. That's it. That's where the money is.
Well, actually, yeah, it's IP or PI, you know, personal injury, you know, so that's where they're making the big money. That's for sure. But I really lucked into this profession as a lawyer, as far as being in the IP. I started doing it over 20 years ago, and it's really coming around where everybody sees the value of their intellectual property. And I do counseling for corporate as well as, startup inventors, just to let them know how to identify what their intellectual property is. Because a lot of times people say, oh, it seemed so easy for me to create this, it's probably not patentable, or I don't have a trademark in it, or, how do I get the copyright? And they don't even understand it. And so even lawyers, they call me and they say, I have a client that has a trademark or a copyright or a patent. I'm not sure which one it is. And they don't, attorneys don't even know what it is, the difference between the different types of intellectual property.
And, I want to start there. And you said something that's very interesting is, they don't know what it is. And it's getting more complicated. Technology is changing so fast, and it's getting so intricate and complicated that, the rules are changing. You got to be up on this. So let's start with, we hear patent infringement, copyright, trademark, trade dress. Let's break down each one of these and give us a real simple explanation of each one.
Okay, what I use is a perfect example, and it's sitting on my desk right now. It's a full bottle of Coca-Cola with the top still on it. and it's sitting on my desk because the Coca-Cola bottle basically is an example of every type of intellectual property. So obviously the Coca-Cola name on it and the circle R, the registered trademark. You mentioned it, trade dress. The look of the bottle. In 1964, Coca-Cola actually registered the trade dress. So they don't want anybody copying the look of the bottle itself. And that's trade dress. The bottle is a container that holds a liquid. It has utility. So there's two types of patents. There's a design patent and there's utility patent. I should say two. There's actually plant patents too, but I've never written a plant patent in my life, so I don't think there's too many people that are doing those. But a design patent would be the look of the bottle. And if I say 7-Up or RC Cola, in your mind, you just picture what those bottles look like. So you can actually get a design patent. And I would bet money that 90% of the bottles in the grocery store, when you go and open the door of the refrigerator at the grocery store, has a design patent of those particular design of those bottles. So the utility is that it holds a liquid, and if you were the first person who invented the bottle, it would be very strong patent to have the utility, a container that holds a liquid. If it was, my wife says not to use this example, but if you were before Jesus Christ passed a bottle around to all his buddies 2,000 years ago and you got the patent on it, it'd be very strong. But the design patent itself is very strong too, because I say if you wanted to sell perfume in a Coca-Cola bottle, chances are it will sell better than the perfume next to it in a regular bottle, just because of the shape of the bottle. Inside the bottle is a liquid, and that's a trade secret. Actually, the Coca-Cola has gone through great lengths to keep it secret. They're not even allowed to talk amongst themselves there's very few people that have the recipe to make it. The marketing, distribution, and manufacturing plants are all separate from each other. They're not allowed to talk to each other. The recipe's kept in a safe. It's a trade secret. And then I argue that it could be a copyright. The whole bottle could be a copyright. It's a fancy work of art. But if you try to register a copyright, a functional item like a glass or a bottle, chances are you won't get it registered. But I can say it's like a pretty statue and it's a copyright. So those are patent, trademark, and copyright. The trademark identifies to the consumer who the source of the product is. They call it a source indicator. Copyright is just what it says. You can't copy this thing, this book, this work of art, this song. You can't copy it. You have a right where nobody else can copy it. And a patent protects the utility of the use of a machine, an article of manufacture, or a composition of matter like a new drug or new gasoline. And also now it's come up lately, and this is what you had just mentioned before, the laws are changing with the business method. And most of these business methods are the apps on the phones. And the Supreme Court are a bunch of guys, and I don't want to make fun of them, but they're like a bunch of guys that don't even know how to turn their computer on. And they've made a rule that's just a couple months old even right now. They even talk about it where the app itself has to have some tie to the real world. It can't just be an abstract idea. So they call it the machine or manufacture or transformation of matter test. So something has to happen in the real world, not just inside your phone, to make these methods patentable. And over the last 3 years, the first case came out about it. It was 3 years ago, and the most recent one's, just like I said, a couple months old, where they've kind of diced it and sliced it and talked about it. And basically, that's what you hear about these patent wars between Sony and Motorola and Microsoft. They're actually attacking each other's patents and getting their patents invalidated. And a lot of these patents that you're applying for now are not getting accepted because of this abstract idea language that the Supreme Court has come up with. So I hope that was brief enough for you.
That was awesome. Yeah. So I want to go back to something that you said about the perfume bottle looking like a Coca-Cola bottle would sell really well. So could I use a Coca-Cola type bottle in the perfume industry?
Yeah, so if you try to do that, I'm sure Coca-Cola would come after you and sue you. And I always say you could win the battle but lose the war. And even if you argue that nobody was going to get confused between you and Coca-Cola, by the time they got their lawyers done with you, it would cost you so much. And I try to tell, not everybody wants to take advantage of the goodwill and the business practices of other companies. And I try to tell, clients, look, do you really want to fight the big purple monkey? You want to stay away from Coca-Cola, right? The purple monkey could do what? Anything he wants to do, right?
Yeah.
You just want to stay away from them. I had a client that we were applying for the trademark for the Viper X11, and the patent office allowed it. And then Dale Earnhardt Jr., he sues anybody that tries to register Viper for any reason, for anything, because he's got a car that's called the Viper. And the patent office basically said, yeah, you're selling flashlights and they're selling cars. You should be able to get that trademark. No one's going to be confused with your flashlights. But the point was, do we want to fight the big guy and fight it out, or do you want to just change your name to the Striker X11 and just call it a day? And what do you think we did on that one? We just changed the name. We don't want to fight with the big guy. So one of the things that I've learned from that one lesson is that even if we have the right to do it, even if all the rules and all the planets are aligned, you just want to stay away from the big names, and even if you want to get too close to them because you don't want to get in that fight. So for now, and since that time, every time I've registered a trademark, I go and look to see if anybody has opposed any similar marks to that, even if we think we should get it. And then we just warn the clients that this could happen. You just want to stay away from, like a Toys R Us or something, and you start doing Desks R Us. You just want to stay away from it. You just want to stay away from it.
Yeah, no question. Get a little too close there. It was funny. I was starting a company about 10 years ago, and we came up with a name, and I did the search on TIFF, and I came back, and everything looked great. And then our attorney asked a question. They said, "Did you search this?" I'm like, "Nope." Of course, we had everything done, right? All the logos, everything was done. And there was an insurance company with a very similar name. We're like, well, we're not an insurance company. I mean, that's not going to be a problem. We were an insurance brokerage house.
Oh, yeah. So it's too close. Yeah.
So I was like, let's call them up and see if they'll let us use it. Well, that was a ridiculous phone call. Let's get head of this huge, international conglomerate on the phone, their legal team, and then ask them if we could use it. So.
Yeah, and I say that, what happens is, and a lot of people want to go, you come up with your new widget and you want to take it to Sears and they want them to sell it. Who are you going to take it to? You take it to the guy who's in charge of research and development. And it's his job to come up with a new widget. And he's supposed to go to his boss and say, oh, they came up with a new widget. And it's like, Jimmy Olsen going to tell the chief, somebody else got this great story. And what does the chief say to him? The chief says to him, why am I paying you $10 a week when I could have you arrested for loitering? But that's the thing. You go to the person who doesn't have really the ability to say yes. He just has the ability to say no because he doesn't want anybody else to know that you have this idea. Or if he was to say yes, he'd probably get fired for doing it. So you're never going to get a yes out of that. Sometimes though, what we found is if like big companies, we had one where it was a label for a vodka. And we had a restaurant with the same name, and they're saying that since it was in the food industry, that the vodka label will stop us from getting it registered. And we argued and we couldn't get it past the examiner. He didn't want to give in on it. So I said, well, let's see if we can buy a bottle of this vodka. And one of my clients is a liquor store, and he's done some patents. And I said, could you find this vodka? And he couldn't even find it. So I thought, well, maybe let's just go see how many trademarks this guy has registered, this company has registered. And they had registered a ton of them. They must have just done them all. They must have done them all at one time. And I said, well, let's just try to see if we fight the mark and try to get it canceled. if they'll even fight it, if they'll just say it's not worth it because they're not selling the vodka. And as it turned out, and I said, look, if they fight us, we'll stop. It won't be a big lawsuit. If they don't fight us, and it'll just get canceled and we'll win. And that's what happened. So we took a shot. We put the cancellation proceeding in, and I was probably right. They weren't selling any vodka. It wasn't worth them putting any more money into this, and we got the trademark registration knocked out, and then our client's trademark application went right in, and I was like on the horn with the trademark office examiner that had our case and told them we won the case and push it through, and it was a big win. But so sometimes you play the game and what do they say, the bear bites you and sometimes the bear eats you. You eat the bear and sometimes the bear eats you.
Now, if you're holding a trademark on something and someone is infringing upon it, and you don't make a case and make it known that they're infringing, aren't you at risk of possibly losing your trademark? Am I mixing apples and oranges?
No, you're right. You're absolutely right. I mean, there's a case that basically says that if you let a lot of people step all over your rights and you don't do anything to protect it, then why all of a sudden you're just going to pick one person to do it against? It doesn't seem fair. They call it, it's a dilution of the mark. And so if the mark gets so diluted that everybody's using it, it's just, like Clorox and you put water in it. It's so diluted, it doesn't clean the floor anymore. That's what you have to do. And they could actually say, look, they've been aware of all these other people using the mark, and it's so diluted that they shouldn't have a case against us today. So absolutely. And that's part of what, like in those cease and desist letters, that's one of the things it says, others have used it in the past. We have made them aware of our trademark and they've stopped using it, and we expect you to stop using it too. So that's part of it. Absolutely. You have to be like, the sergeant, you have to be on. I say it's not so much the sergeant, but like the boy with his thumbs in the dike, and he's always trying to keep the water from going. He doesn't have enough thumbs to put in the holes, and that's the problem with the internet. And I was on this national television show called $1 Million Genius. It was on the History Channel. I don't know if it's on Friday nights, if you've ever seen it.
Yes.
But the guy I worked with on the invention was the Selfie Stick. And you could just imagine, in China and all the different places that have made their own versions of selfie sticks over the years. And there's our first invention was for the actual camera. It was like in the what year was it? It was like in the early 2000s, so it's like 20 years ago, and it was before the Apple came out with the iPhone, where you could see the picture, see the camera, have the reversible camera and see everything. So the original selfie stick was made for actually screwing on a camera to it. So it wasn't the exact selfie sticks that you're seeing today. But if they copy our exact selfie stick, then we have to sue them for infringement. And what happens is there's so many people copying it, it's almost impossible to sue everybody. So what we've done is we've contacted like Amazon or wherever they're selling it and got them to take it down. And then what we've done is just made licensing agreements. If you want to sell it, just give us a piece of the action, and we've worked out deals. So there's no one case is the same. Every single case has its own set of circumstances and how you decide, you're going to work with it. I mean, every single, there's no real template. But yes, you're right. If you don't protect it, they can use that against you in court to say that you let it get so diluted. You knew about these other trademarks and you didn't do anything about it. So we should get to keep using it.
Thank you so much for listening today. I really do appreciate your time, and I hope you found today's show valuable. If you would like to receive these shows automatically to your phone or to your computer, simply go to iTunes and subscribe. After listening to several of the shows, if you're so inclined, please leave us a 5-star rating, as this helps us reach additional people and spread the message. If you're truly committed to taking your life to the next level and doing whatever it takes to become a peak performer, but something's holding you back, something is blocking your way, and you just can't seem to figure out what it is, send me an email to info@thorconklin.com. and I'd be more than happy to get on the phone with you. We'll schedule a 15-minute discovery call. No obligation, no cost. I absolutely love to hear from the listeners, and if there's something I can do to help, I'd be more than happy to do that. Also, if you found something of great interest in today's show and you want to share that with your friends and family, simply go to my Facebook page, Thor Conklin, click on the episode, hit the share button, and share it on your page. You can follow me at Twitter at Thor Conklin. The website is thorconklin.com. We're constantly adding new free resources, discussing additional tricks, tips, tools, and strategies on how to be a peak performer. Remember, I try to keep these episodes short so you can listen to them during dot time, doing other things, commuting, driving, walking, working out. Decide to be a peak performer in all that you do. And until tomorrow, have an absolutely amazing day.
Be on the lookout for part 2 of our conversation with Vincent, where he tells us the 3 problems inventors face and answers whether you need to register your trademark, patent, or copyright. I'll see you guys on another episode of Peak Performers Podcast.